everyone hear me? Can, can, can all our participants hear me? Could you please let me know? You can't hear me. Yeah, can everyone hear me? No, can't hear me, right? Right. My check is done. Perfect. Everyone's mics are fine. Already done the check. My mic check. Right. Can you guys hear me? At least not. Right. Okay. Perfect. Thanks a lot. Right. So congratulations and welcome to the finals of the 8th Victor's Moot. So you've all been through quite a journey and dealt with some tough arbitrators, some tough questions, but clearly you've all done very well. So big congrats on that. And now it's the final stage. So we have our two teams, Team 17, Apit Candy, and Team 31, the Singapore Management University. So big ups to both teams. And yeah, let's proceed with the session. So one last time, I will proceed with explaining the formalities and the rules. So I would like to inform all of you that this session is being recorded for quality and reference purposes, especially for the next year. Before we begin, we would like to remind our councils
Recording
to
in progress.
keep their videos switched on at all times and to please be mindful of their microphones. I would also, I have noticed that you have all renamed yourselves accordingly. Thank you very much. That saves us some time. So could I next ask the first speakers from each party to please let the tribunal know how your times have been allocated for the submissions and for your rebuttals. So Team 17, could you please let us know how much time you have allocated?
Good afternoon, everyone. I will be the procedural speaker. I will be allocating 90 minutes for my submission and 1 minute for my rebuttal.
Good afternoon. We will also be reserving 19 minutes for our submissions and 1 minute for rebuttal for both speakers. Thank you.
Thank you both very much. So the speaking order, as you would now be aware, will be Respondent 1, Procedure, Claimant 1, Procedure, Respondent Rebuttal, Procedure, Claimant Surrebuttal, Procedure, Claimant 2, Merits, Respondent 2, Merits, Claimant Rebuttal, Merits, and Respondent Surrebuttal, Merits. Speakers, I would like to remind you that while you are speaking, I will be sending a message on the chat when there is 5 minutes left of your speech, and then I will send you another reminder on the chat when you have 1 minute left. And I will verbally interrupt you when your time is up. So please, if you are speaking, keep an eye on the chat for alerts. Thank you all for your attention. I will now be handing over the controls over to the panel of arbitrators and starting the timer when Respondent 1 begins their speech.
Can you hear? Okay. We welcome both parties to these arbitral proceedings. And I presume formally to start, as in a normal arbitration, you do not have any objections to the constitution of the tribunal. I would like both parties to affirm that or state any objections they have if they do have.
No, we do not have any objections.
We do not have any objection to legal stuff.
Thank you. So we would have that recorded. And in those circumstances, can we have Respondent 1? I believe we are starting with Respondent 1. Can we have Respondent 1 speaking on procedure?
Good afternoon, members of the tribunal. My name is Sandini Pundira, and I will be appearing on behalf of the respondent, Magnus PLC, as counsel for procedural issues, along with my co-counsel, Whitney Vijay, who will be addressing the substantive issues. This case arises from a contract where my client, Magnus PLC, agreed to transfer 15% of its allocated bandwidth. Payment by Firefly Incorporated. Due to not having received the approval, payment alleges breach of contract. However, my client maintains that the payment was aware of the regulatory nature of this transaction and the involvement of the ETA. I will be addressing two issues today. First, the tribunal does not have jurisdiction to determine the dispute and the arbitration.
Excuse me, respondent, can you hear us?
Yes, Mr. Arbitrator.
Okay, please, I wanted to note that we do not hear your submissions clearly. So since we are having a virtual hearing and it is necessary for us to understand your submissions clearly, I would appreciate if you could make the submissions clearly. And can we do a voice test beforehand? Can we do a voice test now? I think the time must be restarted. Let's stop that and restart the time. But before we start the time, can we do a voice test now? Yeah. Okay. Go ahead. Voice test.
Am I audible, Mr. Arbitrator?
Better. Can you speak a little clearly? And perhaps, I don't know where your microphone is. Maybe you need to bring it a little closer or something like that.
Is it better now, Mr. Arbitrator?
I think your microphone pickup rate may need to be reduced a little, and perhaps the volume needs to be increased from this end. Try it again, please. Can you speak again?
Am I audible now, Mr. Arbitrator?
Reduce the volume from here. Can you speak now? Can we do a test?
Sure. Yeah. Am I audible now?
Yes, much clearer, much better. Thank you. Are we ready to start? Okay, you can start now.
Good afternoon, members of the tribunal. My name is Sandhini Pomvira, and I will be appearing on behalf of the respondent, Magnus PLC, as counsel for procedural issues, with my co-counsel, Whitney Vijay, who will be addressing the substantial issues. This case arises from a contract where my client, Magnus PLC, agreed to transfer 15% of its allocated bandwidth to Firefly Incorporation. Due to not having received the approval yet, claimant alleges breach of contract. However, my client maintains that the claimant was aware of the regulatory nature of this transaction and the involvement of the ETA. I will be addressing two issues today. First, the tribunal does not have jurisdiction to determine this dispute based on the arbitration agreement between the parties. Second, the dispute is non-arbitrable based on the scope of the arbitration agreement. Proceeding on to my first issue, I have two submissions. First, non-compliance of the precondition deprives the tribunal of jurisdiction. Second, the negotiation clause is enforceable. Proceeding on to my first submission, I would like to direct the members of the tribunal to page 7, which would be page 9 of the PDF. Clause 9.2 of the contract designates London as the seat of arbitration. Under Article 28 of the SIAC rules, a tribunal is competent to decide if it has the jurisdiction to hear a case. And this notion is extended to include questions on validity under Article 30 of the Arbitration Agreement, Arbitration Act, 1996. In White versus Kempner, the court confirmed that where parties have agreed to a condition precedent like mandatory negotiation, the tribunal has no jurisdiction unless the precondition is completed. Likewise, members of the tribunal, in ICC case number 12739, the tribunal declined to hear the matter because the claimant had not complied with a mandatory precondition, meaning the arbitration was not validly initiated. These cases confirm that the non-compliance with preconditions makes the arbitration invalid and fall outside the scope of the tribunal's jurisdiction. Members of the tribunal, even if an arbitral award was rendered by the tribunal when there is a matter of non-compliance with a mandatory precondition to arbitration, parties are allowed to challenge the substantive jurisdiction of the tribunal under Section 67 of the Arbitration Act 1996, which as a result, the arbitration agreement shall be deemed invalid at the time of initiating arbitration. Members of the tribunal, this notion is further affirmed in Article 5(1)(a) of the New York Convention, which allows the courts to refuse the enforcement of an arbitral award where the arbitration agreement was not valid. Therefore, members of the tribunal, the claimant's failure to comply with a mandatory precondition to arbitration renders the arbitration invalidly commencing, depriving the tribunal of jurisdiction. Proceeding with arbitration amidst this failure shall render any arbitral award unenforceable. Accordingly, members of the tribunal should decline jurisdiction.
Can we ask you a question in relation to your submissions?
Sure, Mr. Arbitrator.
What is the condition that has not been met, and why do you say that it has not been met?
Mr. Arbitrator, the condition we're talking about here is a mandatory negotiation clause, which is a precondition to arbitration. And the reason why I am saying that this has not been complied with is due to the fact that negotiations had not even taken place. Proceeding on to my second submission, which is that the negotiation clause is enforceable, I would like to direct the members of the tribunal to clause 9.1 in page 7 of the case report, which would be page 9 of the PDF. I quote, "Any dispute shall be resolved by the parties through negotiation, and failing which should be finally resolved by arbitration." End quote. Members of the tribunal, the use of the term shall was considered to be mandatory in the case of Cable and Wireless versus IBM, which was held in 2002. Moreover, members of the tribunal, in Orphan versus Invesco, which was held in 2019, the court confirmed that such mandatory language indicates the parties' clear intention to comply with preconditions to arbitration. Hence, members of the tribunal, the mandatory nature of this negotiation clause clearly indicates the intention of the parties to refer this matter to negotiation and not arbitration. I would like to direct the tribunal to clause 5.3 in page 6 of the case report, which would be page 8 of the PDF. I quote, "In the event that ETA approval is not obtained within 6 months from the date of this contract, the parties shall negotiate." End quote. Members of the tribunal, this clearly demonstrates the parties' intention to resolve disputes through negotiation before commencing arbitration, making it a mandatory precondition. Even if the negotiation clause does not expressly provide for a specific time frame for negotiation, it does not render the negotiation clause unenforceable, members of the tribunal. Because in international research versus Lufthansa, the court held that even though the time frame is not specifically or rather expressly given in the precondition clause, an obligation to follow pre-arbitral negotiation steps is enforceable when it is drafted in mandatory terms. Therefore, members of the tribunal, because clause 9.1 constitutes a mandatory precondition of negotiation to arbitration, despite the fact that it lacks a specific time frame, it does not really matter because of its mandatory nature. Despite the existence of an enforceable mandatory precondition to arbitration, the parties had still not even begun negotiations, members of the tribunal. If I may direct the tribunal to page 21 of the case report, which would be page 23 of the PDF. In the email sent by claimant on 5th of December, I quote, "Do you have any concrete updates from the ETA?" End quote. To which my client has replied stating they're still facing regulatory burden.
Did you refer to claimant's exhibit 2?
Mr. Arbitrator, it's respondent exhibit 1 in page 21 of the case report. It could be page 23 of the PDF.
Please. Carry on, please.
Members of the tribunal, my client has replied stating they're still facing regulatory roadblocks. These are not negotiations, members of the tribunal, but mere status inquiries. In War versus Grant Thornton, which was held in 2012, the High Court of England and Wales held that negotiations require more than just mere communications. They involve proposals, counter proposals, and a genuine attempt to resolve the dispute. In the present case, members of the tribunal, no such negotiations had occurred. The parties did exchange status updates in December, but never discussed any terms or compromises, which does not actually come under negotiations. I would like to direct the members of the tribunal to the last email sent by the claimant in page 22 of the case report, which would be page 24 of the PDF. I quote, "If Magnus is unable to provide a definitive way forward soon, we will need to take action accordingly." End quote. Members of the tribunal, even if the claimant thought that negotiations were ongoing, this statement of the claimant shows frustration, not a strong formal notice of exhaustion of negotiations, members of the tribunal. Moreover, in ICC case number 12739, the court required a party to formally initiate or exhaust the preliminary dispute resolution. Members of the tribunal, the parties exchanged status updates in December, but never discussed any terms or compromise. I would further like to direct the members of the tribunal to page 23 of the case report, which would be page 25 of the PDF. Members of the tribunal, it was only on 31st December 2023 that the respondent even mentioned the possibility of negotiation, stating there may still be room for negotiation. Members of the tribunal, this clearly shows that true negotiations had not even begun before the claimant filed the notice of arbitration just 20 days later. Thus, members of the tribunal, this negotiation clause is enforceable as it is a mandatory precondition to arbitration, which was not even started. Hence, members of the tribunal, the non-compliance of this mandatory precondition deprives the tribunal of jurisdiction. I would now like to proceed on to my second issue. I have two submissions under my second issue. Mr. Arbitrator, I'm extremely sorry, but we can't hear you properly.
Yeah. Okay. Can you hear me? No.
Yes, Mr.
Okay. Right. Can you refer to paragraph 4 of your response to the notice of arbitration? It's on at page 39. You have that?
The response to the notice of arbitration.
Yeah, paragraph 4. Now, is it your argument that negotiations, even if it has started, should be exhausted before going to arbitration, or that negotiations have never been started?
Mr. Arbitrator, my argument is that negotiations had not even begun. It was not started, Mr. Arbitrator.
Isn't that against what you have stated at paragraph 4? Look at the first sentence of paragraph 4.
Members of the tribunal, even though there has been a chain of conversations in Respondent Exhibit 1, they do not include proposals, counter-proposals, or any compromises. And according to the case of War versus Grant Thornton, which was held in 2012, negotiations were required more than just communications. They involved proposals and counter-proposals and also compromises, which in this chain of emails is not clearly evidenced.
No, I'm not on the emails. I'm on your pleadings. If you on 2 occasions in paragraph 4, first line you say submits that ongoing negotiations between the parties. Then the one before the last line, notwithstanding these ongoing negotiations. So haven't you waived that objection? Isn't there waiver and estoppel when you now say that negotiations have not started?
At least in the least an admission that there was some form of negotiations proceeding. In the least.
No, Mr. Arbitrator.
What do you mean no? So the issue is isn't there on the part of Magnus both estoppel and on the part of your argument, isn't it completely contrary to paragraph 4 of the pleadings? See, I would understand if you said negotiations started, it has not been exhausted. I think that is your second point, right?
Yes, Mr. Arbitrator.
Okay. So how can on one point, on one hand you say that there is no, or it has not been exhausted, and on the other hand say it has never started?
Mr. Arbitrator, it was never started to be exhausted.
Okay, go ahead.
So, just to understand the position and set it clearly, your position now is that There were merely communications, there were no negotiations, and since there were no negotiations, arbitration cannot proceed because negotiations are a precondition.
Absolutely, Mr. Arbitrator.
Right. However, you do notice the position in paragraph 4 of your response to the notice of arbitration. Is that correct?
Yes, Mr. Arbitrator.
Okay. Thank you. Proceed.
Proceeding on to my second issue, I have two submissions. First, the parties never intended to refer regulatory matters to arbitration. Second, regulatory matters cannot be arbitrated under the laws of noxious. Members of the tribunal, the claimant was clearly aware of the delays that were supposed to be on the way due to the ETA's approval. Due to this awareness, both parties have negotiated clause 5.3, which states, in the event that ETA approval is not obtained within 6 months from the date of the contract, the parties shall negotiate. Members of the tribunal, this clearly shows the intention of the parties to refer such delays, such matters on delays, to negotiation and not arbitration. Members of the tribunal, I see that I'm running out of time. Could I please be granted with more time?
You can have 90 seconds. 90 seconds.
Members of the tribunal, it is clear that this arbitration was initiated invalidly in breach of a mandatory precondition to negotiation under clause 9.1 of the contract. Such non-compliance deprives the tribunal of jurisdiction as confirmed in English law and arbitral precedent. Furthermore, members of the tribunal, the dispute itself concerns a regulatory approval by the ETA, a public authority that is neither a party to arbitration nor to the contract. Such matters of public law and regulatory oversight are inherently non-arbitrable, members of the tribunal. Therefore, the respondent respectfully submits that the tribunal lacks jurisdiction over this dispute, and since the claim concerns non-arbitrable matters, it falls outside the scope of the parties' agreement and the tribunal's jurisdiction. Accordingly, the respondent requests the tribunal to dismiss the claimant's claim in their entirety. Thank you, members of the tribunal. Mr. Arbitrator, I'm extremely sorry once again, but you're not audible enough.
Can you hear me now?
Yes, Mr. Arbitrator.
Right. Now, I think the last point that you made was that the ETA approval is an issue of public law, and therefore it doesn't fall within the premise of arbitration. Is
Yes,
that correct?
Yes, Mr. Arbitrator.
Right. However, if that is the case, can it be the subject matter of a negotiation? Because if you look at clause 5.3 of the contract, it says that in the event the ETA approval is not obtained within the time period that is specified therein, parties shall negotiate in good faith to determine an appropriate course of action.
Yes, Mr. Arbitrator.
Right. So if there is lack of negotiation on that part, or there's another clause which says that the party who is selling this bandwidth, will exercise best endeavors to get the ETA approval, and if they do not exercise it, aren't those subjects falling within the arbitration clause?
Members of the tribunal.
To add to that, would it not be a contractual obligation in relation to the public law issue, which is subject to arbitration?
Members of the tribunal, I understand your concerns. Even though this dispute seemed to be a failure of the respondent to act according to its contractual obligations, this dispute arises from the delay of the ETA, which is a third party and a regulatory body. Moreover, members of the tribunal, we do not want to hinder the business relationship between the parties by subjecting such matters to arbitration. And also, members of the tribunal, what my client wants is to negotiate this matter and come into a conclusion that is advantageous for both sides.
Thank you.
But the dispute with regard to approval is not the matter in issue at the arbitration, is it? Isn't the dispute having the knowledge that approval was required, that they entered into negotiations and the contract? That's contractual, right?
Mr. Arbitrator, could you please repeat the question?
So isn't the dispute with regard to approval between Magnus and ETA not a part of the dispute between Magnus and Firefly? Isn't the dispute in arbitration the non-disclosure of the approval process? That is contractual.
Mr. Arbitrator, my co-counsel will be establishing this substantive issue by establishing that there has been no breach of the contract on behalf of the respondent.
Yeah, but we are at the moment we are on the procedure, no? On the procedure is on the objection to jurisdiction. Isn't this dispute contractual? Rather, the substantive issue is different. But as a matter of procedure or objection to jurisdiction, isn't the dispute contractual?
I'm so sorry, Mr. Arbitrator. It is not audible enough. Can you hear me? No, Mr. Arbitrator.
Can you hear me now?
Yes, Mr. Arbitrator.
Right. So, you seem to be arguing that the dispute is not arbitrable because this is a regulatory dispute, regulatory issue.
Yes,
right?
Mr. Arbitrator.
But conversely, the summary of facts at page 64 sets out that Magnus has represented to Firefly that it was legally entitled to sell 15% of the allocated bandwidth. Now, if that be the case, right, would that matter not be a pure contractual matter? Not relating to the public law issue, but rather on the representations that has been made and so on.
Yes, Mr. Arbitrator.
What's your response?
Yes, Mr. Arbitrator.
Are you agreeing with my proposition?
Mr. Arbitrator, even though this dispute seems like a contractual dispute, it still arises from the delay of the ETA. Therefore, members of the tribunal, since ETA is a regulatory body, I stand by my statement, which is that this is not arbitrable. The dispute in hand is not arbitrable.
Thank you.
Thank you.
Okay, we have heard the respondent and the objection that has been articulated. So can we move on to the claimant in relation to procedure now? In the same manner as the respondent's counsel, we would like to do a voice test in order to understand whether we can hear you clearly. So let's please proceed with the voice test first. Carry on, please.
Yes. Yes, members of the tribunal. May I check if I'm audible and visible?
Yes, I think you're okay. Likewise, can you hear us?
Yes, we can hear you.
Yeah.
Thank you.
Thank you. You may proceed then to articulate your response, and time starts now.
Good afternoon, members of the tribunal. My name is Chang San Ying, and together with my co-counsel, Mr. Wan, we represent Firefly Incorporated in today's proceedings. As the respondent had set out, parties have indeed entered into a contract regarding the sale and transfer of radio frequency spectrum. However, the respondent has failed to uphold their end of the bargain, which is why we are here at arbitration today. Following this, I make two submissions: that there are no jurisdictional bars to the present dispute, and next, the dispute at hand is arbitrable. Before I move on to my submissions, I note that the first counsel of the respondent had addressed that the tribunal has no jurisdiction and the UK Arbitration Act does not apply. However, parties have consented to being at arbitration today, and following Rule 28.2, the Tribunal 28.2 of the SIAC rules, the tribunal does have the power to rule on its own jurisdiction. Further, members of the tribunal, if I may turn you to page 29 of the record, at clause 9.2, it mentions that the seat of the arbitration shall be London, and as such, the UK Arbitration Act does indeed apply. Now, moving on to my first submission, I make 3 points. First, that the agreement to negotiate in clause 9.1 is too uncertain to be given legal effect. Next, even if it was certain enough to be given legal effect, we have complied with the pre-arbitration condition to negotiate. And third, the scope does fall within the tribunal's jurisdiction today. Now, on my first point of submissions, following recent English case law, such as the 2022 English High Court's case of Children's Ark and Kojima's construction, agreements to negotiate are generally unenforceable. They relied on the 2012 English High Court case of Tang and another Grand Thornton, which the respondent had mentioned earlier, in setting out when agreements to negotiate are enforceable. Yes, members of the tribunal?
Yeah, before proceeding further, can you address us and tell us whether you consider the negotiation as a precondition to arbitration? Is it a condition precedent at all? Do you concede that position that it is a condition precedent?
Members of the tribunal, we do not think that it is a condition precedent to arbitration, given that the agreement to negotiate is too uncertain to be enforced. The reason why it is too uncertain to be enforced is because following the 2012 English High Court case of Tang and another Grand Thornton, agreements to negotiate are only enforceable if there are discernible steps for the process, and if it is specific enough such that the courts can determine whether there has been compliance or a breach. Now, members of the tribunal, if I may turn you to page 29 of the record. May I check if you are with me? At clause 9.1, it states any dispute, controversy, or claim shall be resolved by the parties through negotiations. members of the tribunal, it mentions negotiations without providing any details as to what negotiations should entail. As such, there are no discernible steps. If I may illustrate using a case, such as the 2012 English High Court case of Seoul America and Inessa, parties had agreed to mediate as a form of dispute resolution procedure. However, the court had denied enforceability to the clause given that it did not set out any defined mediation process, nor does it refer to the procedure of a specific mediation provider. As seen in clause 9.1, it does not detail what negotiations should entail, when negotiations should end, who negotiations should otherwise involve, and where negotiations should be conducted at. We note that first counsel of the respondent had relied on the case.
Isn't that
Yes.
implied? Isn't that implied? Wouldn't it be obvious to parties as to how they would conduct negotiations? Do you need to specify all those procedures in the arbitration clause?
Well, Mr. Presiding Arbitrator, the issue of this clause is that there are totally no details at all. In the case that first counsel of the respondent had cited, which was the 2002 English High Court case of Cable and Wireless, in which an agreement to negotiate a dispute resolution procedure clause was upheld, it was only upheld because it included a sufficiently defined mutual obligation of initiating mediation and selecting a mediator. As such, members of the tribunal, we would require...
Sorry, can I interrupt you? But
Yes.
mediation is a more formal process, correct? There is a process of appointing a mediator, there's a process of agreement, but negotiations, isn't negotiations more informal and than mediation? So applying a judgment which relates to a mediation clause, isn't it a bit problematic, where the process of negotiation as stipulated in clause 9 is more informal?
I understand your concern, Mr. J. Sundara. However, if I may illustrate using another case, in 2014 English High Court case of Emirates Trading, an agreement to negotiate in good faith was upheld. However, the reason why that clause was upheld because there was a time-limited obligation to negotiate in good faith for 4 weeks. This provided the courts with a level of certainty as to how to enforce those negotiations. Members of the tribunal, given even at least a time-limited obligation to negotiate in clause 9.1, given that there lacks at least a time-limited obligation, there's no certainty and no details of what negotiations should construe, and as such, following the 2012 English High Court case of Seoul America, the court had held that it would be impossible to enforce it without any certainty. However,
on that point, I do understand the fact that if there was a specific time period within which the negotiations were to be concluded, there would be more clarity. But having said that, this is a negotiated contract between a commercial contract negotiated between two competent parties. And as a precondition, both parties have agreed in using mandatory language that they will engage in negotiation prior to arbitration. So in that situation, isn't there at least an obligation on either party to see whether negotiation is possible?
well, Dr. Gunas Vansa, well, on the issue of parties had intended for negotiations to be enforceable, we submit that at the end of the day, the test is whether the clause is sufficiently certain to be given effect, and this is following the 2012 English High Court case of Seoul America. However, members of the tribunal, even if we were to take the respondent's case at the highest, in which the agreement to negotiate is enforceable, we have complied with the pre-arbitration condition to negotiate. As the members of the tribunal had pointed out earlier, at page 39 of the record, in the respondent's own notice of arbitration, they had mentioned that negotiations have already been ongoing, and this is supported by the procedural order number 2. Members of the tribunal, if I may turn you to page 56 of the record.
Are aware of that. Proceed, please.
Yes, thank you. At paragraph 19, it clarifies that claimant was engaged with negotiations with the respondent till the end of December 2023. Now, the email exchanges in Respondent Exhibit R1, which can be found in page 42 of the record, 43, I apologize, of the record. If you are there with me, at the very first email, members of the tribunal, may I check if you are at the, thank you. Now, at the very first email, it says, following up on our previous discussions. This would suggest that negotiations have commenced since October 2023, which can be supported by our own claimant's notice of arbitration that is found on page 26 of the record. At paragraph 16, we had mentioned that between the months of October and December, parties conducted several rounds of discussions. As such, negotiations have been happening, and it could not have been that negotiations have not begun at all. Thus, given that negotiations have been ongoing since October, and this contract was entered at the start of January, it has been almost a year since ETA approval has not been provided for, and negotiations have been ongoing for 3 months. While First Counsel of the respondent had mentioned in the email exhibits at page 45 of the record that there may still be room for negotiation, we submit that further negotiations would be futile at this stage. This is following the 1998 English High Court case of Halifax Financial Services, where months of unsuccessful negotiations would render further negotiations futile. As such, given that negotiations have already been occurring, we have engaged with the respondent on how to move forward, but the respondent has failed to provide us with a way forward as shown in the second email at page 44 of the record. Members of the tribunal. At the second email of page 44 of the record, the respondent had told the claimant that it may be difficult to move forward unless there is some shift in the regulatory landscape. Given that the respondent has failed to provide the claimant with a way forward and has failed to provide an alternative course of actions, further negotiations in this regard would be futile. Moving on to my members of the tribunal, before I move on to my next point, can I check it?
I think I would like to have a small clarification. So is it your position that at the outset, the portions of the clause relating to negotiations, clause 9.1 is what I'm referring to, are really, I mean, it can be ignored because they are imprecise and vague, and therefore it does not constitute a condition precedent.
Yes, Mr. Presiding Arbitrator, our position is that the agreement to, specifically the fact that the dispute, controversy, or claim shall be resolved by the parties through negotiations is too uncertain to be given legal effect. As such, it does not act as a bar for parties to arbitrate regarding the dispute.
With the rule of construction that when you have words in a contract or an act, they have to be given meaning that has reasonable sense.
Members of the tribunal, the reason why that agreement to negotiate should be unenforceable, because at the end of the day, as shown by Lord Justice Moorbeck, he had mentioned that it was, even if parties had intended for the clause to be enforceable, the court should do so, as it does not set out any certainty and it would be impossible to enforce. Members of the tribunal, even while negotiations can be interpreted reasonably, to do so would be to rewrite the contractual bargain. And at this stage, parties are already at an adversarial position, and to go back to the negotiating table would be against Section 1A of the UK Arbitration Act, in which a fair resolution of dispute must be obtained without unnecessary delay or expense. Members of the tribunal. Yes?
So if your position is correct, what you're basically saying is a party could actually ignore those words and go directly into arbitration, and that would be a valid submission. Is that your submission?
Yes, that is our submission, Mr. Presiding Arbitrator.
But you also concede that negotiations did take place.
Yes. Yes, Mr. Jasundar. Negotiations have indeed taken place, and they started from
Sorry, that's an alternate argument, that if we find that negotiations are mandatory, your second argument is, even if it is mandatory, you have gone through negotiations. Is it?
Yes, these arguments are to be taken in the alternative.
Okay, thanks.
Thank you. Moving on to my next point, this issue falls within the scope of the tribunal's jurisdiction. At clause 9.1, the phrase "any dispute, controversy, or claim" is one that is drafted widely in scope. As such, it should be interpreted according to the 2007 House of Lords case of Fiona Trust, which states that the scope should be interpreted according to how rational businessmen are likely to have intended their dispute, unless there's express language excluding this dispute. Given that there is no express exclusion, the dispute of misrepresentation and breach of contract, which my co-counsel will be addressing later on, falls within the scope of clause 9.1. Now, moving on to my next submission, that the dispute at hand is arbitrable. As mentioned earlier, the dispute is one that is a contractual matter and not one that involves regulatory bodies. Following the 2023 English Privy Council case of Family Mart China Holdings and Ting Chuan, subject matter non-arbitrability doctrine rests on the notion that some matters so pervasively involve public rights and concerns. Members of the tribunal, this is a clear contractual matter. Following page 28 of the record, we are submitting. Members of the tribunal, can I check if you are with me? We are submitting that there has been a breach of clause 3 and clause 5.1. This does not concern the regulatory body at all, given that this is a pure breach of contractual term. Further, we admit that this issue does involve the ETA approval. However, it does not meet the high threshold of pervasively involving public rights and concerns. Further, this should be taken with the 2022 English High Court case of NDK and World Holdings, which says that English courts will not likely conclude that a dispute between commercial parties is incapable of being submitted to arbitration. Members of the tribunal, I've reached the end of my submissions. Do you have any questions for me?
Thank you. We are possessed of your arguments. Thank you very
Thank
much.
you. Thank you very much. I now conclude and will pass my time on to my co-counsel, Mr. Wan.
Okay, I believe in that context, what remains next is to listen to the rebuttals in relation to the procedure by the respondent, and followed by the rebuttal or surrebuttal by the claimant. Are you ready to proceed?
Yes, Mr. Arbitrator.
Yeah.
Members of the tribunal, the claimant brought up that we as respondents do not agree with the fact that English law is applicable to the arbitration agreement. However, members of the tribunal, that is not the case. The English law do apply to the arbitration agreement. According to Enka versus Shrub, the most real and closest connection to the arbitration agreement applies. Since clause 9.2 has designated London as the seat of arbitration, it allows English law to be applied to the arbitration agreement. And English law further supports that the arbitration agreement should be deemed invalid when there is a matter of non-compliance of a mandatory precondition. Thank you, members of the tribunal.
Specific clause in English law that you rely on in order to support that proposition?
Members of the tribunal, under section 67 of the Arbitration Act, even if an arbitral award was rendered by the tribunal when there is a matter of non-compliance of a mandatory precondition to arbitration, parties are allowed to challenge the substantive jurisdiction of the tribunal, which means that the arbitration agreement shall be deemed invalid and the arbitration will be deemed invalidly commenced.
Proceed, please. Have you concluded your submissions?
Yes, members of the tribunal.
Thank you.
Thank you, members of the tribunal.
Can we move on to the surrebuttal of the claimants?
Members of the tribunal, we do not dispute clause 9.2 and clause 8.1, and we are in agreement with the respondent that this contract and this arbitration agreement shall be construed in accordance to English law. Further, the respondent has raised the issue of Section 67 in challenging the award by the tribunal. However, this issue is premature given that an award has not been provided for at this stage. And since parties have consented to arbitration here today, the tribunal does have jurisdiction over this arbitration. Thank you.
Thank you very much. Right.
Thank you.
Yeah.
No, they have given up the right to the rebuttal rights, so we will. Yeah, we will be moving on to number 5. Yes.
Sorry, Mr. Presiding Arbitrator. We are unfortunately unable to hear you.
Can you hear us now?
Yes, Mr. Presiding Arbitrator, we can hear you now.
Thank
Would
you
you
very-
like me to proceed?
Yeah, so thank you very much for those submissions on procedure. We are now ready to proceed to the merits hearing, and in the merits hearing, the hearing will be commenced with the submissions of the claimant. So we are ready to hear the claimant, if you're ready. Are we ready to proceed?
Yes, Mr. Presiding Arbitrator, we
Right.
are ready to proceed.
Okay, so in those circumstances, your time starts now.
Members of the tribunal, the background of the contract is this. The claimant was a newcomer from Westland, eager to pursue a new transaction of telecommunication bandwidth transfer in Eastland. The respondent was a licensed and experienced telecommunications company who had provided telecommunication transfers for many years. With this background context, the respondent had reached out to the claimant on 15th of January 2023, representing that they had the legal entitlement to transfer the bandwidth over to our claimant. This representation was then later condensed into Clause 3.1b of the contract at page 28 of the record, where the respondent once again represented that there were no regulatory restrictions. However, as time went on after the execution of the contract and the claimant had not gotten the ETA approval required for the transfer of bandwidth, the claimant then reached out to the ETA when they then realized that the ETA approval had not been granted and that the respondent had not complied with the RFS Act. Additionally, later information surfaced from a newspaper article at page 31 of the record about past similar breaches by the respondent on unrelated transfers. With this, I now turn to my submission that the respondent is liable for breach of contract on misrepresentation and on other grounds. We make 4 points in support of this submission. First, the respondent had fraudulently or negligently misrepresented their ability to transfer the bandwidth over to the claimant, specifically their abiding of the RFS Act. Second, the respondent had breached Clause 3.1, Paragraph A of the contract, as they had not obtained RFS Act before entering. They had not obtained the specific approval under the RFS Act before entering into the contract with the claimant. Third, the respondent had breached Clause 5.1 of the contract, as they had not acted in their best efforts in obtaining ETA approval. And lastly, that in any case, the limitation of liability clause does not apply, as the respondent was had conducted willful misconduct or gross negligence in obtaining ETA approval. I now turn to my first submission. That is, the respondent had fraudulently or otherwise negligently misrepresented to the claimant that they had the specific approval under the RFS Act.
Can I disturb you for a moment? So you referred us to the seller's representations in 3.1a and b, but likewise you also have clause 5. Now in clause 5, you must be aware of clause 5.1, where the seller has a best efforts obligation, and the buyer, on the other hand, in 5.2 acknowledges that regulatory processes are subject to the discretion of the ETA. So do we not have to read those together?
Mr. Presiding Arbitrator, we would like to distinguish. Sorry, I'm unable to hear you, Mr.
Can you hear me now?
Yes, thank you
Yeah,
so much.
if I may
Dr.
add to what the lead arbitrator said, if you look at 5.2, all the risks associated with the refusal of ETA has also been accepted by the buyer according to clause 5.2. So then that also leads to the question that if you are well aware of the fact that ETA approval was necessary for the contract to come into effect, and then you were also aware that the seller could only exercise best efforts, irrespective of whatever representations they made, then you have also accepted the risk, but then you have gone ahead and met certain expenditures and incurred certain costs, buying equipment and so on, which you now intend to claim from the seller on the basis that seller has misrepresented. So how do you overcome the risk-bearing factor that it casts upon you in terms of clause 5.2?
Thank you, Mr. Presiding Arbitrator and Dr. Gunawansa. I will first address Mr. Presiding Arbitrator's question. We would like to clarify that clause 5.1, which is the respondent taking its best efforts to obtain ETA approval, is a future condition. This can be separated from the present representation the respondent made in clause 3.1, paragraph B of the representation that there were no regulatory restrictions that they knew at the time of entering into the contract. We submit that this is a false representation. If I may turn members of the tribunal to page 25 of the record. In our notice of arbitration.
What is the clause again? Clause 6.5?
Clause. I'm sorry, Mr. Presiding Arbitrator. We were saying that clause 3.1, paragraph B, is a present representation made at the time of entering into the contract that we represent is false. If I may turn members of the tribunal to page 25 of the record. At paragraph 8. Sorry, Mr. Presiding Arbitrator, we are unable to hear you.
Yeah. You see, according to the facts that we gathered, the seller is entitled to sell 10% without approval. If he goes beyond that, he requires approval. Right?
Yes.
Now, in this context, haven't you included clause 5 in the contract in the context of requiring approval of the ETA for the transfer? Because if it was only relating to 10%, this clause was not required. Hasn't it been included specifically because of the reason that if you go beyond 10%, approval will be required. So in that context, when you say that you are assuming that risk, isn't that the risk that the buyer is assuming?
Mr. Presiding Arbitrator, we disagree that there is only one approval, which is the specific approval in question. We submit that there are two different approvals: a general standard industry process of obtaining any ETA approval for any transfer of bandwidth. This would be following page 27 of the record. In Claimant Exhibit C1, in the definitions of ETA approval, where they refer to ETA approval as, I quote, the regulatory clearance required from the Island Telecommunications Authority for any transfer of bandwidth allocation. This is further supported by Respondent Exhibit R3. If I may turn members of the tribunal to page 48 of the record. Members of the tribunal, are you there with me? At paragraph 2 of our internal memorandum, we had submitted that I quote, "It is understood that any transaction of this nature is subject to standard industry processes and approvals, which are outside our direct control." This is the general standard industry processes that is subsumed in the ETA approval, but does not mean the specific approval under the RFS Act. Members of the tribunal, we therefore submit that clause 5, we cannot hear you at the moment.
Right. Now, can we go back to clause 5 and clause 3, page 28? Screen went off.
Sorry, Mr.
No,
Sundara.
just give us a second. There is a technical glitch. Okay. Right. We have okay. So we are looking at page 28. Now, in view of the provisions in clause 5, now you said that 3.1b is a present representation, correct?
Yes, Mr.
But in view of the matter set out in clause 5 with regard to regulatory approval, do you think that clause 3.1b is a fundamental term of the contract, or shouldn't it be read in the context of what is set out in clause 5?
Mr. J. Sundara, we submit that given that regulatory restrictions here are of a general nature, they have to be interpreted in line with clause 5. We submit that clause 5 on ETA approval refers to standard industry processes and does not include the specific approval under the RFS Act. Therefore, the RFS Act, the specific approval under the RFS Act should be included under the regulatory restrictions that the respondent has represented to the seller that there are none of, at clause 3.1 paragraph
So
B.
that is going up to 15%, which is the subject matter of the contract, makes 3.1b a specific provision as against the general provisions in clause 5. Is that the argument?
Sorry, Mr. J. Sundara, if you may clarify your question?
No, so what you say is 3.1b, because of the subject matter being 15% of the bandwidth, is a specific representation in respect of the 15%.
Yes, Mr. J. Sundara.
Okay, thank you.
So if that risk is not being accepted by you, or rather not transferred to you by 5.2, what is the risk that 5.2 is talking about? It says the buyer accepts all risks associated with delays and denials. Now, if the risk in 3.1b is not accepted, what is the risk you're accepting?
Thank you, Mr. Presiding Arbitrator. We submit that the risk accepted in this case is a scenario where the respondent and the claimant have both put their best foot forward, and they have asked the ETA and followed up on what they should have done as in their best efforts to obtain the ETA approval. Earlier, Dr. Gunawansa also mentioned about risk allocation in clause 5.2. We agree that we as the claimant will undertake these risks associated with delays or denials of such approval. However, it has to be taken in the context of the representations and warranties made at the time of entering into the contract. The claimant was under the conception that the respondent had followed the RFS Act. this is the main reason why they had entered into the contract for the specific obtaining of the 15% approval. Therefore, we submit that we will bear risks when both parties have taken their best foot forward, which we submit the respondent has not done in this case. Does that answer your question, Mr. Presiding Arbitrator?
Proceed, please.
With that, I now turn to establishing fraud. Members of the tribunal, as held in the 1889 UK House of Lords case in Derry and Peake, and subsequently affirmed in the 2013 English Court of Appeal case of Eco3 Capital Limited and others, and Lutzin Overseas Limited, a misrepresentation is fraudulent when the representer made a misrepresentation either 1. Without belief in its truth, or 2. Recklessly as to whether it's true or false. We would like to submit that the respondent, when representing to the claimant that they had followed the RFS Act, was either reckless as to its truth or did not believe what they had represented to the claimant. Members of the tribunal, at page 31 of the record, at Payment Exhibit C3, members of the tribunal, are you there with me? At page 31, the respondent had previously, in a similar unrelated transaction, breached the RFS Act. And this breach of the RFS Act was known by them to be serious. If I may turn, members of the tribunal, to the right column of the newspaper article, in the first paragraph, the ETA spokesperson had commented on the severity of not abiding by the RFS Act. And I quote, "Ensuring compliance with spectrum regulations is crucial for maintaining fair competition and market stability. Any violations will be addressed with appropriate regulatory action." Members of the tribunal, this was with regards to an unrelated transaction in the past, as clarified in page 57 of the record. At Procedural Order number 2, members of the tribunal, are you there with me?
Yes, we are.
At paragraph 30, where the tribunal had clarified that Claimant Exhibit C3 was related to unrelated transactions. With this background, we submit that the respondent would have known that the RFS Act was a pertinent consideration, yet they had decided to lie to the claimants that there were no regulatory restrictions. Additionally, the respondent was a licensed telecommunications provider and experienced in such transactions. This would necessarily mean that they would know of the RFS Act and had done their research regarding that. As such,
Can I pause you there? Now, this was, even according to your submissions, a fairly large and important transaction. It would have been an important transaction from the perspective of your client as well, because you were going into the country. So in those circumstances where you are making an acquisition of frequency, and that being an important regulatory issue in any country, did your client not do early due diligence activities in relation to the regulatory aspects?
Mr. Presiding Arbitrator, I believe you are referring to page 28 of the record at clause 3.2 paragraph A, where our client had represented that it had conducted its due diligence. We submit that we had indeed conducted this due diligence and we knew of the RFS Act. However, we were misrepresented by the respondent on the 15th of January 2023 that they were legally entitled to transfer this bandwidth.
So therefore, when you entered into clause 5.2,
Yes.
You entered into clause 5.2 pursuant to the due diligence that you had done and in the context of the risk that you were aware of.
Mr. Presiding Arbitrator, we submit that the due diligence standard that we should be held at are the best efforts on our part to ensure that we are ready to receive this bandwidth transfer. It does not extend to the respondent's own actions. This is why we submit that clause 5.2 does not apply, because clause 5.2 envisions a situation where the claimant and the respondent act together in their best efforts to obtain ETA approval. I hope that answers your question, Mr. Presiding Arbitrator.
Thank you. Proceed.
I now turn to my second submission, that the respondent had breached clause 3.1 paragraph A when it had warranted that it held valid rights to the allocated bandwidth and had the authority to transfer the same to the buyer. Members of the tribunal, when reading clause 3.1 paragraph A, a reasonable person would interpret the term authority to include acceptances and approvals that are required to transfer this to the buyer. As earlier established, the ETA approval mentioned in clause 5 refers to standard industry processes and not specific approval. Therefore, we submit that the authority would include the specific approval which the respondent actually did not have at the time of entering into the contract. Therefore, this would be a breach of clause 3.1 paragraph A. I now turn to my third submission, that is that the respondent had breached clause 5.1 of the contract as they had not acted in their best efforts for the transfer of bandwidth. Members of the tribunal, the only evidence we have of the respondent reaching out to the ETA can be seen in Respondent Exhibit R2. This would be at page 46 of the record. Members of the tribunal, are you there with me? Where the respondent had sent an email out to the ETA a mere only 24 days after the contract was entered into. This does not reflect the standards of best efforts. Best efforts, as held in the case of the 2010 UK Court of Appeal case of Jet2.com Limited and Blackpool Airport Limited, would be to require the party to exhaust all reasonable causes of action that are open. In this case, we submit that the respondent had only sent an initial clarification. They had not provided any distinct and concrete evidence of follow-up actions. Members of the tribunal, as held in the 2011 UK Court of Appeal case of Wetton and Ahmed, documentary evidence that is conspicuous by its absence can support an adverse inference. Given that the respondent has not adduced any direct documentary evidence of follow-up communications with the ETA and have only merely asserted in the email correspondences that they have followed up with the ETA, we would like the tribunal to draw an adverse inference that there is no evidence to support the respondent's claim of actively following up with the ETA, or alternatively, that there is evidence that is adverse to their case. I now turn to my last submission, which is that the limitation of liability clause does not apply because the respondent had conducted willful misconduct or gross negligence. Members of the tribunal, as explained earlier, the respondent had not acted in their best efforts when obtaining the ETA approval. Instead, when entering into the contract with the buyer, they had misrepresented their ability to even obtain the ETA approval in the first place, as they had breached the RFS Act. by not obtaining the specific approval in Section 12, Paragraph 2 of the RFS Act. We submit that this constitutes a willful misconduct, as that would constitute fraud, or in any case, that would be gross negligence on the failure of the respondent to follow up with the ETA. Members of the tribunal, I've come to the end of my submissions, unless I may be of any further assistance.
Why do you say that they have reached their best efforts obligation?
Sorry, Mr. Presiding Arbitrator, I'm unable to hear you at the moment.
Why do you say that the respondent has breached their best efforts obligations?
Mr. Presiding Arbitrator, we submit that they have breached their best efforts because they have only initiated correspondences with the ETA 24 days after the contract was entered into. Additionally, they had not provided any evidence of follow-up communications with the ETA to obtain the ETA approval, which will expedite this ETA's decision. Mr. Presiding Arbitrator, I hope that answers.
Thank you.
Unless
Very
I may
well.
be
Thank you. I think we are possessed of your arguments. So we will now move on to the respondent on the merits. Is the respondent available?
Yes, Mr. Presiding Arbitrator.
Yeah. So we will proceed to hear you starting now.
Good afternoon, members of the tribunal. My name is Ritni Vijayveera, and I appear on behalf of the respondent, Magnus PLC. I'll be addressing the substantive issues in this dispute, and I'll also be responding to the opposing counsel's submission through the course of my own submission. Truth be said here, this contract was built on express conditions, agreed by both parties. When regulatory approval did not materialize, it was not due to instability or dishonesty, but the natural nature of a condition subsequent, expressly contemplated in the contract itself. With this, I have two main submissions before the tribunal today. First, that there was no misrepresentation as my client made a conditional and qualified statement. Second, that no breach has occurred as regulatory approval was a condition subsequent and my client fulfilled all obligations that were needed. Proceeding with my first submission. The claimant asserts that a misrepresentation was made on 15th of January 2023. However, this submission is legally and factually flawed, members of the tribunal. First, the nature and contents of the representation are ambiguous. I may direct the members of the tribunal to procedural order number 2, which is in page number 32 of the case brief or page number 34 of the PDF. In paragraph number 2, it clearly confirms that the statement was forward-looking and the exact
Sorry, this is item 2 in the procedural order number 2?
Yes, Mr. Arbitrator. Clearly states that the statement was forward-looking and the exact words and the medium used were not stated. A vague and predictive statement does not amount to a definitive representation of fact. In the case of Bissett versus Wilkinson, held in the Privy Council, it was stated that a statement of future intention is not misrepresentation unless the maker had no such intention at the time of making it. Here, the respondent genuinely believed that regulated approval was likely, but made no unconditional assurance about this. According to the case of Derry versus P, held in the House of Lords, it says that three main criteria should be proven in order to prove fraudulent misrepresentation. First, that there should be a false statement. Second, that the false statement should have induced the claimant into entering into the contract. And third, that there should be losses occurred due to the reliance on this. To prove the first statement of false, which is of a false statement that was made. Members of the tribunal, the statement as I confirmed above is a forward-looking statement. And moving to the second criteria, the respondent's statement was made in anticipation of regulatory approval, not in defiance of non-obstacles. And the contract itself affirms this. If I may direct the members of the tribunal to page number 6 of the contract case brief or page number 8 of the PDF. In clause 5.1, it states that it conditions the transfer on regulatory approval, while clause 6.1 also states that it limits liability for failure to obtain such approval, unless there is gross negligence or willful misconduct on behalf of my client, which was neither substantiated by the claimant. And the opposing counsel stated that there was a misrepresentation that occurred and that my client should have taken approval before entering into the contract itself. If I may direct the members of the tribunal to procedural order number 2, which is page number 35, paragraph number 27. It clearly states that the RFS Act only mandates that approvals from the ETA has to be obtained prior to the physical or technical transfer of the bandwidth allocated to an operator. This clearly states that my client does not have to obtain approval when entering into the contract itself, rather when transferring the bandwidth. And this proves that no misrepresentation has occurred as the claimant was not induced into entering the contract. And if I also direct the members of the tribunal to clause number 3.2, my apologies, 4.2 of the contract, which is in page number 6 of the case brief or page number 8 of the PDF. It clearly states that the payment shall be made in full within 10 business days of the execution of this contract, without any deductions, set-offs, or withholding of taxes. And as procedural order number 2 confirms, the execution in this regard refers to the technical transfer of the bandwidth itself. And the claimant, however, states that they have incurred losses after sending a price of US dollars of 15 million. I would like to state that in this regard, as even though the contract itself states that it should be transferred within 10 days of the execution of the contract, the claimant on their behalf has breached the contract itself. And this fulfills all the 3 criteria that are needed in the case of Derry versus P to prove fraudulent misrepresentation, as the claimant in this regard has not occurred any losses, but rather breached the contract on their part. Proceeding with my second submission.
Why do you say that? Why do you say that the claimant has, the claimant has breached the contract on their part?
Mr. Presiding Arbitrator, to answer your question, in clause 4.2, it clearly states that payment shall be made in full within 10 business days of the execution of this contract, without any deductions, set-offs, or withholding of taxes. And if I may direct the members of the tribunal to pay procedural order number 2.
Yeah, proceed.
in paragraph number 18, it clearly states that the term execution refers to the technical transfer of the bandwidth itself. And in this regard, the claimant has not got the transfer of bandwidth here, but has proceeded with making the consideration of US dollars 15 billion and is now saying that they have incurred losses due to this transaction. If I answered your question, may I proceed with my submission?
No, wait. But that is with regard to section 12 of the RFS Act, right? In
Yes.
4.2, you're talking about execution of the contract.
Yes, Mr.
Is it,
Arbitrator.
how do you say that it's the same definition must be given to in same definition in RFS Act should be given to clause 4.2?
Mr. Arbitrator, to answer your question, it is stated in the case brief itself more than 10 times the word execution. And this does not, and it is clarified in the procedural order number 2, what execution actually refers to. And in this regard, that is why we submit that execution, even though has not taken place, the claimant in this regard has transferred their consideration and is now saying that they have incurred losses due to this.
Can you hear me?
Yes, Mr.
Yeah, but
Arbitrator.
if your argument is correct, then you have benefited from the payment. No? A payment has been made as consideration by the claimant to the respondent. Respondent has accepted payment, has not returned it, right? So if that is the case, could it not be argued that the claimant made the payment in view of the misrepresentation made by the respondent that they have the legal capacity to ensure that the required licenses will be granted by ETA?
Mr. Arbitrator, to answer your question and connecting back to what my co-counsel stated, in the email chain, we have stated that we are willing to go for potential alternative solutions. But because of the fact that the negotiations didn't even take place, we have not been able to go and seek potential alternative solutions in this regard. And due to this, even though they have transferred a payment of 15 million US dollars, we have not been able to offer potential alternative solutions.
Point taken, but having said that, I wonder if there's merit in the argument that
Mr. Arbitrator, I can't hear. You are not audible.
Can you hear me now?
Yes, Mr. Arbitrator.
Yeah. So I take the point you just mooted now, but having said that, I wonder whether there is any merit in the position that you are taking that the claimant has in fact breached the contract. If at all the claimant was negligent in making the payment to you, which you have very happily, your client has very happily accepted, right? But merely because they have made the payment prior to the transfer of what was, promised to be sold, could you identify that as a breach of contract?
Mr. Arbitrator, yes, even though it is stated in the contract itself to make the payment after within 10 days of the execution of the contract, the claimants have rushed into making the payment. And in this regard, my client cannot do anything because they have rushed into making the contract. And also the matter pertains to the transfer of bandwidth. And my client with the ETA has a relationship of a licensor and a licensee. And we do not have an authority or autonomy to get the transfer of bandwidth or approval from the ETA in this regard. We have done our best efforts which was in the control of our hands, and we have gone for all our best efforts, such as in making the application on 25th of February 2023 and in continuing dialogues with the claimant themselves.
Okay, very well. I'm sure we'll hear from the claimant as well on this point, yes.
But what you're saying is completely opposite to the representation in 3.1a. No? Now you say you don't have the authority to transfer because the ETA must give that approval. But here there is a representation, word to word, representation that your client has the authority to transfer. Correct?
Yes, Mr. Arbitrator.
So it's contradictory.
Mr. Arbitrator, to answer your question, the claimant also states that the statement which was made on 15th of January 2023 was what induced them into entering into the contract. But as I stated earlier, this was a forward-looking statement with future intention. And if I may direct the members of the tribunal to page number 32 of the case brief or page number 34 of the PD. In paragraph number 7, it clearly states that the RFS Act was in force at the time of executing the contract, and all acts and regulations of Eastland can be accessed freely through relevant government portals. And this also highlights the contractual clause which in regards about due diligence. Even though these were public, the claimant in this regard have not taken due diligence to make sure that there were regulatory approvals. And also about the statement that was made on 15th of January 2023, even though we have stated that we are legally entitled to this transfer, this is contingent to the regulatory approvals that we should get. And if the claimant in this regard conducted due diligence, they would have known properly that there were certain regulatory approvals that should be granted.
Now, in that context, I draw your attention to the word executing contained in procedural order number 2, item 7. Now, that cuts across your argument that execution is basically getting the approvals. Do you have any response to that?
Yes, Mr. Arbitrator. Even though it is stated about executing the contract in this regard, if I may direct the members of the tribunal to respond on exhibit number R3, which is in
Can I
page number
pause you
20.
there? Can I pause you there? Now, would you agree with me that there is no separate definition of the term execution in the contract?
Yes, Mr. Presiding Arbitrator.
Right. So in that context, wouldn't you have to give the general interpretation of the term execution when you're reading that clause?
Yes, Mr. Presiding Arbitrator, but it is also stated that it is regarding the transfer of the technical transfer of the ban.
But isn't that performance of the contract as opposed to execution of the contract?
It was, even though it is regarding the performance, it was clarified in the PO2. It is regarding the technical transfer, Mr. Presiding Arbitrator.
Okay. So now in that context, would you agree that you have received consideration, you have got the money, but the transfer has not taken place?
Yes, Mr. Presiding Arbitrator.
So in that context, would you have the ability or right to keep that money going forward?
Mr. Presiding Arbitrator, even though right now I cannot decide on this matter because I have to consult my client in this regard. But we have, even though since we have the consideration, this is why in the email chain that we have stated that we are willing to go for potential alternate solutions. And as
why do you have to consult the client? That is one of the reliefs that they're claiming. They're asking for the refund of the money. They're asking for compensation. That's how they have constituted their figure of 30 million, I believe. So one component of the 30 million is a return of consideration. So you should have instructions on that.
Yes, Mr. Presiding Arbitrator, but it is also stated in paragraph number 17 of the procedural order number 2 that the outcome of the approval process is yet to be determined, and it is not in the hands of my client to get the approvals as it pertains to the ETA in this regard. And as it is yet to be determined, I am yet to consult my client if it is possible for us to return the consideration in this regard.
In other words, what you're saying is there is no failure of performance. The matter is still pending.
Yes, Mr. Presiding Arbitrator.
Thank you.
Members of the tribunal, I believe that I'm running out of time. May I be granted an extra minute to conclude my submission?
Yes, because we did ask you questions. You will have 90 seconds going ahead.
Thank you, Mr. Judge. To conclude my submission, it is clear my client did not misrepresent the situation, but expressed a conditional intention in this regard, and that no contractual breach has occurred as non-transfer resulted from a failure of a condition subsequent, a risk which was expressly anticipated and contractually managed. The contract reflects a balanced and commercial allocation of risk, which the claimant now seeks to ignore. With this, I would like to conclude my submission. Thank you for listening to me, members of the tribunal.
Just one question. Do you consider these words, there are no regulatory restrictions, vague? Would you consider the words, there are no regulatory restrictions, as being vague?
Can I know which clause you are referring to?
No, I'm just asking you. Leave the contract aside.
No, Mr. Arbitrator.
Okay. And those specific words are used in 3.1b.
Yes, Mr. Presiding Arbitrator, even though it is stated in 3.1b regarding regarding that there are no regulatory restrictions, as Mr. Arbitrator clearly pointed out earlier, in clause 5.2, it also states that the buyer acknowledges that regulatory approval processes are subject to the discretion of the ETA, and they accept all risk associated with delays and denials of such approval. And in this regard, the contract was made with both negotiations by both parties.
Okay, thank you.
Thank you.
Thank you very much for those submissions. Now I think it is time for us to move on to the rebuttals. Can we have the claimant formulating the rebuttal on the merits, please?
Yes, members of the tribunal, can you hear me?
Yeah, you can start now.
Members of the tribunal, earlier my learned friend had mentioned that our client had breached clause 4.2 of the contract by not submitting the payment within 10 days. However, if I may clarify, clause 4.2 refers to 10 business days. That would mean that our client would have to pay by 14th of February, and as such, there has been no breach of contract under clause 4.2. Members of the tribunal, the current case is that the respondent had misrepresented that they had this specific approval of under the RFS Act before entering into the contract. This was why the claimant had agreed to pay the respondent the sum under clause 4.2, 10 business days. This would also explain why this is in contravention of Section 12, Paragraph 2 of the RFS Act, as the claimant had always believed the respondent had the specific approval. I end my rebuttal. Thank you.
No further clarifications, that's all you need to clarify, is it?
Sorry, Mr. Presiding Arbitrator, I cannot hear you.
Clarifications, that is all you need to clarify.
Thank you.
Yes, Mr. Presiding Arbitrator. Members of the tribunal, the learned counsel for the claimant stated that regarding the clause of 4.2, and I believe that it was misunderstood as we were referring to the execution of the contract, which is regarding the technical transfer of the bandwidth itself. And we stated that the claimants have rushed into making the payment of 15 million US dollars. And regarding the second point that was made by the learned counsel for the claimant, they said that they believed that all regulatory approvals were gained. But in this regard, it is clearly stated in the contract that they should have conducted regulatory due diligence on the regulatory framework applicable. And in this regard, it was also available to the public. Thank you for listening to me, members of the tribunal.
Thank you very much to the parties. We will talk to each of you after the evaluations that we are going to do. Thank you very much.
Thank you.
Thank you so much.
Thank you so much, members of the tribunal.
So yes, thank you all for your submissions. That was now we are being faced with one of the most talented arbitration tribunals that I personally have ever seen. So I'm sure it was a bit challenging for all of you facing down with the questions, but you all did very well. So we will be moving you into the waiting room now to relax a little bit and while the judges deliberate. So yeah, my technical officer will be moving you into the waiting room. So feel free to chat with each other and discuss and relax. Thank you.
Recording stopped.
How long do we have? How long?
everyone. So, as you can see, it was not an easy task judging all of you in the finals.
Recording in
You're all
progress.
extremely talented. But in the end, our judges have our arbitrators have made their decision, and your fate has been decided. So, of course, we won't be revealing the results now itself. That will be revealed later on during the closing ceremony. However, I will be handing the control of the meeting back to the judges, the arbitrators, in order for their feedback.
So, okay, first of all, let me start by thanking both teams for the effort that they have put in. And I must say that it was at a fairly high level. We are also very impressed by the manner in which you all reacted to the questions that were asked. Because I believe you had questions coming from 3 Presidents' Council. You handled the pressure very well. Your reactions were very good. We would be very impressed if that kind of reactions came from the 2 parties in an actual arbitration where actual counsel who are experienced are appearing. And we are very impressed that that type of a reaction came from you, and your responses were quite good, very related to the questions that we asked. So we are impressed by that. Congratulations on that achievement. You did display the fact that you had done a fair amount of research in relation to various matters, and I think it was quite helpful. You had a reasonable grasp of the questions that were before you, but I must add, you could have made some better arguments in relation to certain positions, and you did not exploit the brief fully. So there were lots of other areas where you could have drawn attention to, or you could have made use of for the purpose of sort of bringing up the position of your client's party. The other thing that we need to bring to your attention is when you're using an argument, when you're using an argument or when you're formulating an argument, please don't form an argument which has no reasonable chance of success. It looks bad for your case when you do that, right? So always, when you have, 100 arguments to choose from, choose the best for you. And you don't have to present all the arguments that you have if you don't foresee a reasonable chance of success. Right? So don't present arguments for the sake of presenting an argument. That is something that you need to remember very well going forward. So whilst you are formulating arguments, formulate them, test them beforehand, check whether there is a likelihood of success or not, check whether it would, or rather consider whether it would be attractive to a tribunal or not. And if you think that it doesn't have a reasonable chance of success, in a normal sense, don't use it, because it weakens your case in a particular way. At the same time, some of the arguments that you did formulate and some of the comebacks that we had were quite good. We were very impressed by the manner in which you were able to answer questions that were posed by us. So at the end of the day, I mean, the main presentation is prepared by you, and you generally prepare well. We know that. So therefore, we don't have to make much comments about that. But I think we are extremely impressed by the manner in which you handled the questions that were posed by us. You were not uncomfortable with those. You were ready to accept them, and you responded extremely well. So congratulations on that. Keep at it, right? You all are doing very well. If you do keep like this, you will probably be very good in practice if you intend to enter into practice in future. So all the best for your future from all of us over here. And I will ask Dr. Gunawansa and Mr. Jayasundara if they have anything to add.
Yeah. Again, very well done for both teams. I don't wish to say anything much at this stage because I agree with everything that my colleague, the lead arbitrator, said. So he gave you some insight into how to perhaps improve your skills, going forward and do that. As far as today's moot is concerned, I don't wish to comment now that we have already marked, both teams, and you will find out who is the actual winner, in an hour or so. So I want to keep that exciting going. And again, all the best with whatever you decide to do with your careers going forward. Thank you.
Thank you very much, and again, congratulations for a well presented case. It's just one thing that you remember. You must remember: the facts don't change, the facts don't lie. You can't mess with the facts. You have to keep to the facts and mold your law around the facts. So the minute you mess with the facts, then it's going to be difficult, right? Subject to that, thank you very much.
Okay, so congratulations and all the best on your future endeavors. Thank you very much.
Thank
Thank
you.
you
Thank
very
you so
much.
much, and thank you for the wonderful opportunity. We will take our leave now.
Thank you very much, sirs. So before we close out the session, everyone please smile for the camera. We are going to take a photo now. So, yeah. So 3, 2, 1. Right. Thanks, everyone. So you all did a very good job, and we'll be finding out which one of you won in a few hours. In a few hours. But regardless, you made it all the way here, and that is an achievement in itself. So big congrats to you all. And even if, I'm speaking to all participants in general, whether you were eliminated in the preliminary rounds or you made it all the way to the finals, you all made this Victor's Moot successful, right? You guys, your talents and your dedication was what made this event colorful. So thank you all for your efforts, and wish you all the very best. And may the best, the winner has been decided, and may the best arbitration team win. Thank you all. Have a nice day.
Thank you.